Salutations, respected viewers. This is George from Ireland. I'm beginning a series on common law. That's the law which you find in most English-speaking countries. It's sometimes called English law. I don't strictly mean just the law in England, but as I say, this system is spread out across the world. Well, we have to start with some very fundamental principles. Some things are not strictly law. So, humans, we are social beings. There are 7 billion of us. We need to interact. We try and regulate how we interact. Not all of us are good all the time. And we need laws to help us avoid harming others, to enable us to reach agreements and ensure those agreements are honoured. How we allocate property, things like that. So people have property, someone dies, and he or she has not written a will. That's to say a document saying who the property should go to when he or she dies. And these are some of the reasons why we have the law. And so who should inherit, let's say it's a woman's property? Should it be her sister? Should it be her son? Or what? Should it be her boyfriend whom she lives with? We see that's where law steps in. And if it was to be shared, this property, in what proportions would it be shared? So the law dictates this sort of thing. There was a renowned 18th century Irish statesman, Edmund Burke, and he said how when we frame laws, we can't do so on the assumption that everybody is wise and good. We must make laws bearing in mind that some people are tempted to turn bad. Some people are foolish. So, common law, it's for most English-speaking countries. Now, confusingly, there's another meaning of common law, but about laws which are justified by past practice, but I'll come to that later. So common law started out in England, wasn't completely original to England. It draws upon some laws from what we now call Germany, the Angles and the Saxons had. These are various areas of northern Germany back in the Dark Ages, a little bit from Roman law as well. The British Empire used to exist, and it spread to many countries in all the continents of the world. And these colonies became independent over the centuries, and most of them have retained the bulk of common law. So there are roughly 60 countries in the world which are common law countries. So it's the legal system of the United States, of India, Kenya, Nigeria, Jamaica, Fiji, could go on and on. Some countries, for instance, Pakistan has got a blend of common law and Sharia law, and sometimes in issues dealt with under the Sharia system, that's the Islamic system. Some at times it's dealt with under the common law system, things like that. The same is true of various other Islamic states, such as Bangladesh. Nigeria is divided into states, federal republic, and some of them have Sharia law, the northern ones with Muslim majority. So mainland Europe has the Roman law system, so going back to ancient Rome. There are some striking similarities between Roman law and common law. Now, you can easily get mixed up because Roman law is also called civil law sometimes. It goes back to Justinian, the Byzantine Empire. That Byzantine emperor, that was the eastern third of the Roman Empire that broke away. And Justinian famously wrote the corpus of civil law. Now, civil law is a very tricky expression because it's got another meaning inside the common law system, which is to say non-criminal law. But again, I'll come back to that much later. So as you can see, there are lots of homonyms, so people can easily be flummoxed by this sort of thing. So law is never easy, but it's less challenging for those with a broad vocabulary, those with a high verbal intelligence. So there's always been a dialogue between Roman law and common law. In the 1970s, these systems started to converge as the United Kingdom acceded to the European Economic Community, as it then was. However, they're still distinct. Brexit is happening, and as the United Kingdom leaves the European Union, they'll probably diverge a bit, probably not all the way. There are three common law countries which are remaining in the European Union, being the Republic of Ireland, Malta and Cyprus. So this course will focus chiefly on England and Wales. lawyers and judges in England and Wales learn from lawyers and judges in other common law countries as well. So we should call it English and Welsh law, I suppose. However, it's always known as English law. One of the key principles of common law is precedent. That is looking back to previous rulings by courts, stare decisis, or stare decisis, as some people pronounce it, as in stand by the decision. So courts can break with precedent. They don't have to follow what courts have previously done. If there's a particularly compelling reason to do so, we realise that things evolve over time. So courts in the United States, for example, they look back to past judgments. They try to be consistent. However, courts can change their mind on the separate but equal issue. For instance, when it was originally held that states were allowed to have black people and white people treated equally but in separate facilities, later on the Supreme Court decided that that was nonsense. You couldn't separate people, that wouldn't be equal and that would be necessarily racially discriminatory. So the Plessy versus Ferguson case was revisited in the United States in the 1950s, but perhaps I'm delving too much into the particulars at the moment. So the United States, well, had its first permanent English settlement in 1607, Jamestown. Prior to that, the United States will look back to the courts of Wales and England. Until the mid-17th century, courts in England and Wales transacted their business in Latin. Therefore, a great amount of the legal terminology comprises Latin phrases. You don't need to ever have studied Latin in order to study English law. So judges in common law countries, they chiefly look at the decisions handed down by the courts in their own country. But as I say, they will consider judgments from other countries as well that are not quite so persuasive. So common law needs to be studied in a certain order. You should commence with common law reasoning and institutions, and then public law. When I studied law, was completely autodidactic. I foolishly tried to dive straight into contract, reading a statute book. No, you will be very lost. So get yourself a good textbook. So we've got to lay the foundations of common law, and once you comprehend common law reasoning and institutions as well as public law, then you can build on that contract law, criminal law, and so forth. Move on to property and tort, European law, equity and trusts, things like that. Though the foregoing are vital to any law degree, you can branch out into various optional areas of law. The electives in a law degree would be international law, human rights law, Islamic law, criminology, commercial law, intellectual property, admiralty. There's an endless list. So, how is law made? Where does it come from? Well, it's often made by statute. No, not statue, statute. Okay? So it's got 3 T's in it. A statute is a law which is made by Parliament or any legislature, right down to, I suppose, even parish council level. So Parliament debates issues facing the country. There's a bill, which is a proposal for a new law, which is debated by Parliament. And if there are enough votes for it in the House of Commons and the House of Lords, then it's passed. And then the words are read out, La Reine le veut, the Queen wants it, it's signed by her into law. Incidentally, it doesn't always become law the day that happens. Sometimes there's a period before it actually takes effect. But that'll be written into the legislation. So legislation is another word for law passed by a legislature. A legislature is an elected lawmaking body, Parliament, the Welsh Assembly, a county council, the London Assembly. They're legislatures all over the world. So the Queen's signature is the merest formality, and it's assumed to be automatic. The monarch is supposed to be above the political hurly-burly, and she maintains the strictest neutrality on political matters. So no monarch has refused to sign one of these bills for 300 years, and once signed, a bill becomes an act. It's known as the whatever act. Sometimes brackets the year it was passed. Notice it'll be the year it was passed, not the year it took effect. For instance, the Irish Disestablishment Act was 1868, but it only kicked in 1870. So in Commonwealth countries where the Queen does not live, but she is the monarch, the Governor-General signs the acts on her behalf. Of the 54 Commonwealth countries, she is a head of state of 16. Most Commonwealth countries are republics. Perhaps I ought to have explained what the Commonwealth is. So the British Empire was gradually dissolved from the 1950s onwards. Most erstwhile British colonies chose to be members of the Commonwealth. Some have chosen not to do so. So the Commonwealth is this voluntary organisation for discussion and cooperation. It doesn't have much power. But, you know, the United States is not part of it. Israel's not part of it. Palestine's not part of it. Myanmar's not part of it. Zimbabwe's coming back. That's about it. Republic of Ireland, we're not part of it. So Parliament can make law, and that is their primary function. Adult citizens of sound mind, those who are not in prison and not peers of the realm, are permitted to cast their votes in elections. So people choose their representatives through the electoral process. Parliament is therefore said to be enacting the popular will. Walter Bagehot was a celebrated 19th century scholar, and he penned a tome entitled The English Constitution. Perhaps he ought to have called it the British Constitution, but he didn't. Anyway, in those days people often said England and English, even referring to the whole of the United Kingdom. And he famously wrote, "Parliament is omnipotent in all things except the power to destroy its own omnipotence," which is to say that whilst Parliament could make or unmake any law, it could not give away its ability to make or unmake laws. So the English Constitution is often called Bagehot, as in the name of the author, and it's regarded as a work of authority and part of the United Kingdom's constitution. Says who? Well, that is the very nebulous thing. I don't know who actually said that it's part of the UK Constitution. Erskine May is a book on parliamentary procedure, and that too is held to be a work of authority. So it's a very questionable, mysterious thing what the UK Constitution actually is. There's a bit unsatisfactory, I know, but there we are. So the United Kingdom's Constitution is uncodified, as it's not brought together in a single document. Some people have said it's an unwritten constitution. So in that sense, it's unique, so far as I know. So it's important to remember that one of Parliament's functions is repealing laws. That's say getting rid of it. We're going to throw that one out. So laws passed by Parliament are statute laws. And that's why I talk about statutory rights. Statutory meaning the adjective of a statute. And they're on the statute book. You can buy books with the laws, and they're in very turgid prose. There are a lot of technical terms in there that if you're a newbie to law, you might find impenetrable. So Parliament can delegate its right to make laws to other bodies or persons. So that's why there's been devolution in the United Kingdom for over 20 years. And Westminster said, all right, we devolve our power, we give some of our power in relation to Scotland to a Scottish Parliament to deal with certain issues solely for Scotland. The Northern Irish Assembly would be another example. The London Assembly, the Welsh Assembly, county councils, things like that. Parliament can also empower a government minister to make or unmake laws pertaining to his or her particular area of responsibility. Another key point, government is divided into three branches, the legislative, executive and judicial branches. Well, I've already talked about legislatures. Executive, well, that's the Prime Minister, the Cabinet Ministers, various government ministers, those who give orders, say, execute it. Execute doesn't simply mean judicially punish with death. No, execute can mean do it, like an executive in a business. And the judiciary means the judges, the courts. There's a separation of powers. These are the three branches of government, and none of them should be overmighty. They have their different areas, and they don't always cooperate. And in a sense, that's good. This is an example of checks and balances. There was an anomaly that was addressed quite some years ago with the Lord Chancellor, who was in the House of Lords, part of the legislature. He was a judge, so part of the judiciary, and he served in the cabinet, so part of the executive. This could not be. So there was the Constitutional Reform Act, and the situation was changed. Secretary of State of Justice, that office was created. So some of his powers were taken away. Incidentally, in English law, we'll say he, him, his, use the masculine pronoun, but it's understood this it also includes the feminine pronoun she, her, or hers. We don't always bother saying he or she. If I say he, be it understood, this could be she. Because obviously until perhaps a century ago, women couldn't be elected to parliament or anything like that, couldn't be lawyers or judges. And so the older texts wouldn't even consider that a woman could hold these offices. So let's think back to ancient Greece, to Plato. And he gave the analogy of the cloak of invisibility. Imagine you could swathe yourself in some cloak and be completely invisible and be certain that you could commit any crime and get away with it. You're guaranteed never to be caught. Would you be tempted to abuse that power? Would you harm those who've wronged you? Would you steal anything? Well, many people would succumb to the temptation to abuse this magical power. And it's on that basis Plato argued that therefore governments must not be all-powerful. If they're too puissant, they'll be tempted to misuse it. Lord Acton was a famous British constitutional theorist of the early 20th century, and he wrote, "Power tends to corrupt, and absolute power tends to corrupt absolutely." It's often misquoted. People forget the word tends. So there are various principles of common law that pertain to government. But anyway, that's enough for the moment. I'll come on to those later.